kind of segued into this perfectly, because what I'm going to talk about is the Fourth Amendment and the Fifth Amendment. And I am going to focus on things you guys are probably interested in. Little things like this, cell phones. There is a ton of litigation that has been happening in the past 10 years on this. And the courts have not caught up with where we are with technology. And that's part of the issue. And that's what we're going to talk about. So first thing, let's just look at the Fourth Amendment and try to understand what's going on here. The right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall be issued but upon probable cause. That phrase is so important, probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Probable cause is a high standard. You have to have very articulable evidence to get a probable cause warrant. That's a high standard. Now, when you hear about some of this stuff that's coming down the pipe, that standard that we're going to, the bar is down here, and we just dug a hole and moved the bar a little bit lower when it comes to digital stuff. This is what I'm concerned about. So we look at the Katz case from the late 1960s. This is the case that essentially describes what a search is. And you have to have two conditions met. The first is whoever you're surveilling or potentially searching has to have exhibited a subjective expectation of privacy. Remember, there's a difference between those two words, and yeah, I'm going to be an English nerd too right now. Objective versus subjective. Subjective means you expect privacy.
You personally.
Yeah, you personally. You expect privacy in your home, right? You expect the police not just to barge in at any time, beat down your door, and say, I think you're a drug dealer, right? Well, can they? Yeah, there's what they call the warrant exception, that they can come in, and if they've done surveillance, they've done whatever, with some of the stuff I'm going to talk about, they can absolutely bust in because they already got a judge to sign off on a probable cause warrant. Now, the second part of this is the interesting part. That subjective expectations one society as a whole is prepared to accept as reasonable. This is the harder part of the test. Take the house example. Would you say most people in society expect to have privacy in their homes? Now, let's kind of go out. Would you expect you and your vehicle to have the same amount of privacy that you had in your home? No. But I'm going to throw you a trick question real quick. What about motor homes or travel trailers? Let me derail tech for 1 second and explain the weird thing about this. If you've got a motorhome or a travel trailer on the road, it's considered a vehicle. And so your expectation of privacy is lower. But if your motorhome or travel trailer is parked, hooked up to water, hooked up to power, it's a habitation. It's a home. So it changes. That's one of the few things that can change character. And this is sort of the battle that we're dealing with right now with data. Because think about your phones. How much data are you actually storing on your phones versus that's being sent to the cloud? That brings up this. And this is the heart of the battle. The third-party doctrine. It comes from Smith v. Maryland, 1979. And usually when you see citations like this, these are Supreme Court cases. A person has no legitimate expectation of privacy in information he voluntarily turns over to third parties. So think about cell phones. Think about right now, what is your phone turning over to AT&T, Verizon, Sprint, T-Mobile right now? It's turning over your IMEI. If anybody knows what that is, that's the unique identifier on your phone that says this is your phone. And that's what the police commonly use to trace you to that phone. You go get a postpaid account, you know why they want your name and address, social security number, and all that stuff like that? Because it links that individual ID on this phone to you. The second part, GPS data. GPS data is being sent all the time because every phone has GPS, right? So where's that going? It's going two places. One, it's going to the carriers to help geolocate where you are at any time. And two, it's going to the cloud-based servers like Apple Cloud, or if you got an Android using Google services or Samsung services, because it's helping support the apps you're using. When you use Yelp, what is it doing? It's using location data to help you find restaurants around you, right? When you turn on the weather app, what is it doing? It's using GPS data, Wi-Fi data, and also triangulating your cell phone signal to tell you where you are at any time. And you know how good these things are now? If you have a phone that's been bought after 2017, it can pinpoint you down to 25 feet. Ankle monitors cannot even do that. Justice Roberts, in a case we'll talk about, Chief Justice Roberts akined the modern cell phone to an ankle monitor we voluntarily wear. That's what they are.
Yeah, where's 25 feet? Maybe that.
That's how accurate they are. So we got that. But see, here's the problem with this third-party doctrine. The third-party doctrine says we have no expectation of privacy unless turned over to third parties. And this was the rule literally up until about 5 to 7 years ago. So there was a lot of people who got caught in the dragnet of the confusion over third-party doctrine. But see, the thing is, we have cases we're going to talk about in a second that have tried to clarify this, but the problem with it is there's still gray areas, and I'll get to the gray areas in a second. So let's start with Riley v. California. This is a 2014 case. This is an important one for when you deal with the police officer on the side of the road. Law enforcement cannot search your phone for digital information without a warrant, even incident to arrest. What that means is, let's say, unfortunately, you get pulled over for driving drunk, you get pulled over, and the cop says, okay, I want to see your phone, I want to see where you came from. Why they want to do that is neither here nor there, but a lot of times it's sort of a dragnet in order to say, okay, I might got him for a DWI, and was he dealing drugs too? It's equal opportunity searching is what I call it. But the thing is, this case said you cannot do that. You cannot just randomly get somebody's phone and say, okay, give me your passcode, open it up right now, I want to know where you were. If you voluntarily do that, that's your bad. Don't do it. Believe me, they will try. They will try. Oh, you have to do that. You have to. No, you don't. Riley v. California says you don't. But here's the thing. We've had clients in the past that did not understand this. Just because this says the police officer cannot compel you on the side of the road to open your phone does not mean he cannot seize your phone, take it down to the police station, and then get a warrant to try to compel you to open that phone. That's the stuff we'll get to in a second. So Riley v. California says it's really the one that's going to protect you on the side of the road, okay? That's what it does. It protects you on the side of the road. And still, your phone can get seized. Absolutely can. But see, the thing with Riley is it was very narrowed to a certain number of issues about traffic stops. That was the context the case was in. Context matters to the Supreme Court. Let me just give you the spiel about the Supreme Court. Context absolutely matters to every case, because if you don't have the proper context, the Supreme Court's going to say this. We're going to narrow the decision down to something that only works in this case. So what happens, defense lawyers, when you try later to go in and use that same case to say it's like your case, they're going to shoot you down saying, no, it was narrowed just to that one case only. So Riley's interesting because of two issues. They leave the issue of exigent circumstances up for debate. And what I mean by exigent circumstances is something where the police officer can say, I know a crime is happening right now, and I have to get in that phone. So let's brainstorm a second. What would be a circumstance where a cop would pull you over and think that I have to get in that phone right now? Think about it. They're hard to come up with, aren't they? Had a law school professor say it best on Exigent Circumstances. In the home, it's like this. The best case that you will ever prove for exigent circumstances is the police officer that used to patrol neighborhoods literally on foot walking by, and you're dumb enough to have your window open and you're pouring a ton of cocaine down the toilet. That's an exigent circumstance because you have contraband that you are trying to dispose of to hide from law enforcement. That's one of the few times that cop can bust down your door. But how do we put this in context of digital privacy and digital rights? What about encryption? In 2014, your phones, iPhones and everything like that, did not have the level of encryption that they do now. They're using what's called 256 AES encryption. And that is a very high standard that literally you could take some very, very smart computers and it would still take them almost 100 years to crack. That's how good 256 AES is. So if you want to know the encryption standard used for VPNs, or if you got a choice like I do here on this, 256. It's the way to go. But encryption wasn't a big deal in 2014. So what does this mean? Potentially in the future, a case could come up where they say, encryption is so prevalent now on phones that this doesn't apply. We can force somebody to open that phone. But I don't think it's going to be that one. I think it's the second one. You know with your iPhones, and you know with your Androids, that you can remotely wipe data on your phones, right? That's going to be the issue, and I guarantee you, if I had a crystal ball, that's where we're going to litigate next. Because, let's say this, and this is similar to a case that happened recently that made it up through a state court in California. The police had a warrant to go bust in a house they suspected people were cooking methamphetamine. They go in this house, and they find that there's a ton of cell phones around. So obviously they were using different phones to contact the people on the street to move the product to market. They tried to get a warrant to essentially get everybody there arrested to give their fingerprints to open these phones. And so what ended up happening? They denied it because they said it was overly broad. But they left the option in there open that if one of those phones, even one of them, had started being remotely wiped, now they could compel somebody and throw them in jail if they didn't open that phone right then. See, the devil's in the details. Always is. So here's a question. Do you need a warrant to obtain cell site location data? What cell site location data is this? This is the stuff your phone is manually and automatically sending to your carriers, to T-Mobile, to AT&T, to Verizon. This is stuff like what towers you're connected to, your IMEI number, your phone number, what numbers you're dialing, what numbers are calling you, how long the calls are going on, and oh yeah, all that pesky geolocation data down 25 feet. So what do you think? You think you need a warrant to do that? What do you think?
No, because it's public information.
Third-party doctrine, right? Yeah, well, we just talked about third-party doctrine. Well, here's the case that came to save us. And I truly mean this from a digital privacy standpoint. This is the case that really tried to come save us. It's Carpenter v. U.S. in 2018. And I just talked about the difference between automatic and intentional CSLI. Automatic is the stuff that your phone is sending at all times. The geolocation data, things of that nature. Intentional stuff is when you open a text message, when you make a phone call, things of that nature. There's a difference between automatic and intentional. It really doesn't matter to this thing right here. If you want to see the problem, this is the problem. I said in the beginning, the probable cause is way up here, right? I want you to read this a second. 2703D can compel production of stored communications when specific and articulable facts show that there's a reasonable ground to believe that the contents of a wire or electronic communication are relevant and material. So, probable cause is the high standard. Relevant material is down at the basement. Proving relevancy is easy. Proving relevancy goes like this. Well, I know this guy was driving in a neighborhood that's known for drug dealing. He's driving a car that drug dealers typically drive, so it's relevant to get in his phone and see who he's been calling. You know what that's called? That's called piling inference upon inference upon inference. That's not really, is that working with any true articulable fact about the person themselves? No. That's bias upon bias upon bias. But that's still relevant in material. This is the battle right here. The Stored Communications Act is the battleground. So what Carpenter tried to do is draw a line in the sand. And he says this: a warrant is generally required to obtain CSLI. And you read this quote, and this, if you understand really the ramifications of what this is doing to privacy, it just scares you a little bit. Whoever the suspect turns out to be, he has effectively been tailed every moment of every day for 5 years. And the police may, in the government's view, call upon the results of that surveillance without regard to the constraints of the Fourth Amendment. You know what the 5 years is? That's how long the carriers are required to keep your data. Doesn't matter if you don't pay your bill. Doesn't matter if you change your phones. Doesn't matter any of that. 5 years. They have your data for 5 years. So what does this mean? This means, in most general context, you need a warrant to obtain that type of data I just talked about. But we got a problem. The exigent circumstances. You see the pattern here. This whole thing of exigent circumstances keeps coming back. And the problem is, what about this? Let's say, if you ever got on your phone, you ever got an Amber Alert on your phone, right? Let's say the police in Houston are looking for a child that's missing because a stepfather decided to kidnap the child or something. That's exigent circumstances. And they could pull literally all the data from the area where this child is located, geofencing, and go in and say, it doesn't matter if you were there for good or ill purposes, your data is being given over to the government. And this is what we have to wait. And this is getting, let me get out of the law, take off the lawyer hat for a second, and put back on the historian hat or the social scientist. We're in a battle between weighing public necessity and privacy. That's the battle we're waging, is public necessity and privacy. Is it necessary to try to find a missing child as quick as possible? Absolutely, from a public necessity standpoint. Okay, does anybody remember the third Batman movie? The one with Christian Bale. No, I'm sorry, it was the second one. It was the one with Heath Ledger and the Joker. When he had that whole system set up where he could literally listen in to every phone call in Gotham City like that because he was trying to figure out what the Joker was. Remember that? This is what's going on every day around you. You don't even know it. It's happening. And then Carpenter helps. Believe me, this is the case we needed. But then the problem is, and I love Chief Justice Roberts because if you look at our Supreme Court makeup right now, he's the one that is never afraid to make tough decisions. And he did in this case, based on the facts he had. But he had to blur a line on this because, in this case, Mr. Carpenter, the guy whose data they got, the police had been getting over 128 days worth of data. 128 days tailing him. So the result they came out with is if the police are requesting over 7 days of data, you need a warrant. But they speak nothing about under 7 days. So do you think that's still right for abuse under 7 days? Yeah. So for every push we're getting towards more privacy, we're still restraining some in the cause of public necessity. Okay, so how about this one? Is unlocking a phone with passcode self-incrimination? Now we move from the Fourth Amendment to the Fifth Amendment. So can a police officer just walk up to you and say, I'm going to throw you in jail if you don't open this phone right? Okay, let's think about what the Fifth Amendment says. You don't have to self-incriminate yourself, right? But the problem is we've got to look at things about what actual communication of self-incrimination is. We do not have a Supreme Court case on this, everyone. We do not. This is the closest we've got, is Commonwealth of Virginia versus Boss from 2014. It was a circuit court opinion. This is not even a Supreme Court opinion. So what happened is law enforcement asked the court to compel a defendant to either disclose his passcode or give up his fingerprint to unlock a phone. And so what happened is you got this split ruling. And these are the worst. When it really comes to these types of issues, you want something that is clear-cut as possible. This said there's no Fifth Amendment protection for your fingerprint, but there is Fifth Amendment protection regarding your passcode. And they're quoting this right here from this case from 1967. The privilege protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature. Okay? We got to draw a line there on that word testimonial. What is testimonial? When the police officer says, tell me your passcode now, is that self-incrimination? Are you communicating the passcode to me? Think of that. If he says, tell me the passcode, or write it down right now, are you communicating? You absolutely are. You're absolutely communicating. So the Fifth Amendment protects you. But what about a fingerprint? Is your fingerprint communication? No. And here's where the gray area begins and leads into where we are right now. Here's the question. Provide a fingerprint to unlock a cell phone. Now we got to phrase it with the only thing we've got is unlocking a cell phone via fingerprint a testimonial act for purposes of the Fifth Amendment. Well, in 2014, the answer was pretty much a resounding no, you don't have Fifth Amendment protection. But we have this case from 17. And it clarifies. And once again, this is the first state Supreme Court case to deal with this. This is 2017. Okay, for everybody who knows tech, how long was Touch ID around at this point? Came in on the iPhone 5S, so it had been thereabouts 2012, 2013. So you have about 4 or so years where this is a huge gray area. And what they say in this case is the Fifth Amendment privilege against the self-incrimination does not protect a person from being ordered to provide a fingerprint to unlock a seized phone. They're clear on this one. An act of providing a fingerprint is not a testimonial act. And you know what they do? They do the same thing they do on cases if you ever get pulled over during a DWI weekend during the holidays and they say, a judge is on call to draw your blood. That's what this case does, is it says providing your fingerprint is no different than blood draw warrant requirements for a DWI case. You don't want to give over your blood when you're drunk on the side of the road? You know what? There's a magistrate judge on the phone that I can call right now. They'll fax a warrant down to the hospital and they'll go draw your blood whether you like it or not. Same thing here. Did that really help anything? No. This is a problem. And then we get this one the same year. And I love these cases because these are ones that typically go through FISA courts. Courts where you don't know anything about the case. These are the secret courts that exist in America today. And this is a federal case that wanted a search warrant to compel every person. Remember I talked about this a little while ago. Compel all people present at a specific time and location to provide a fingerprint to open their phones. They didn't know who each individual phone belonged to. All they knew is there are 10 phones and there were 10 people there. But it was not a foregone conclusion that these phones matched these specific people. So this gets distinguished from this other case right here, the diamond case, because you don't know for a fact that that specific person had, with that specific fingerprint, had that specific phone. So the idea is you are giving testimony to self-incriminate yourself when they line you up in all those phones right there and they say, tell me which one's yours. You see how razor thin that line is right there? That line is razor thin. Now here's the interesting one. Biometric face scans, face ID. Is this a testimonial act? This is a recent case as of just this year. And this case, from a persuasive standpoint in any other state in this country, has almost zero authority. It's from a magistrate judge. This is a judge that would be called on to give blood draw warrants and to advise people of their rights after they're arrested. This is not an appellate court. This is not the Supreme Court. This is a lower court. And what this magistrate judge said is they denied a search warrant that would have compelled an individual to unlock a phone with face recognition. And the argument they make is compelling. They argue biometrics serve the same function as passcodes. So if we're, okay, just follow the logic train here a second. If passcodes are testimonial in nature because you are giving over information to unlock something that's encrypted, right, your phone, how is a face scan or a fingerprint any different? Because it's serving the same function. The function is it is opening the phone, decrypting the phone, to get that testimonial information that could incriminate you on said phone. This is a great argument. Honestly, this is an awesome argument. But the problem is it was done at such a low level that we don't have anything after it yet. So, you want my advice? Use a passcode. If you care about digital privacy, you care about your privacy, use a passcode. Because ever since Carpenter in 2018, none of these have been precedential from the Supreme Court level. And so, okay, how?
Sorry to jump in here.
Yeah, go ahead.
Yeah, I love that you do the tech cases, first of all, because I am not really tech literate. But second of all, yeah, the reason cases like this involving tech like this are so hard for the courts to keep up with and stay on top of is because you know how fast our tech changes.
Yeah.
I mean, the first iPhone came out, what,
2007.
2007?
I picked up the first iPhone in Longview, Texas. I remember that. There was
Yeah,
only
so
5 people in line in that small city to pick that up.
Yeah, look how far we've come from the very first iPhone. So yeah, our tech moves pretty quick. Our courts do not. And part of the reason they don't is because of just the process that it involves to even get to an appellate court or the Supreme Court.
And the money involved.
The money too. But yeah, the first hurdle that we have to deal with is courts can't issue what they call advisory opinions.
That's the important one.
Yeah, that is, courts can't just look at the issues that are circulating around and say, okay, well, here's what we think on how this would go. Here's what we think on what the law would say about this. They can't do that.
No.
They have to wait for an actual case involving that issue to be in front of the court before they can say anything about it.
So somebody's got to get arrested and somebody's got to get
So there's hurdle number one. You got to have a case show up at the trial court level that involves these tech issues. Yeah, someone's got to be the guinea pig. Someone's got to be the guinea pig. Someone's got to take the fall for it.
Yeah.
That's advice we give our clients a lot is this is a gray area, here's where we think you should be cautious, here's what might work out, but do you really want to be the guinea pig?
Yeah. Especially, and those are really the Second Amendment context. People that are very, very proud of those rights, and some of them literally would. They would be okay being the guinea pig in those cases.
But yeah, we tell our clients here's where the gray area is. If you're going to do that, just ask yourself if you want to be the guinea pig here. But that's hurdle one is you got to have an actual case. It's called an actual case in controversy. You gotta have an actual case in controversy before the court can even look at the issue, and then it first gets decided at the trial court level. And if there's really no question as to what the law would be on it, it doesn't go anywhere because you're not gonna get anything you're not gonna get an appellate court to review it.
Questions of fact don't matter.
You're not gonna get an appellate court to review it.
It's all about questions.
So yeah, it's gonna take an area of law that hasn't really been answered yet, so you haven't answered at the trial court level. The side that lost has got to decide that they have enough time, enough,
Money.
enough money to deal with it, enough, mental energy to keep dealing with it.
Because you're looking at 5 years.
Yeah, because you're looking at, 1 or 2 years at the trial court level to get that answer. Yeah, you're looking at probably another 5 years at the appellate level.
Yeah.
And that's just an appellate decision, which is still better than, like you said, your little magistrate opinion there, but it's still not the best, it's still not a Supreme Court case.
10 years.
Yeah.
10 years to get an answer. From the time of incident until you render a decision, it's on average 10 years.
10 years. And then, of course, with the way our tech's going, by the time you get that answer from the Supreme Court, old tech at that point.
That's what's happening here. That's what's happening in these cases. So let me
So
go.
that's why it's so hard for these cases to deal with tech issues.
Let me go utterly Orwellian on you for a second on something that happens every day around you. There is a technology called Stingrays. It's made by a company called Harris, and Harris is a company that is extremely private about what they do. When I mean extremely private, to the point to where they sign non-disclosure agreements, so whatever law enforcement entity uses their products, they can get into civil trouble and get sued for telling another law enforcement agency, for telling a court, for telling an attorney, any of this information. This is super secret kind of private stuff. So what Stingrays are cell phone tower simulators. Around you at all time, your phone is connected to usually 1 to 2 cell phone towers at a time. And what it does is it finds the best signal, and that's the one it uses. When you want to make a call, when you want to send a text message, look on the internet. Stingrays, they're also known as IMSI catchers. What they do is they essentially are a man-in-the-middle attack. What they do is they sit between your phone and they sit between that real cell phone tower. And what they do is they capture data. That's all they do. It doesn't matter if you're a good guy, bad guy, or no one cares. They are capturing data. In Texas right now, Fort Worth PD, Houston PD, and the Texas DPS actively use Stingrays. There is no Supreme Court case addressing this issue. There's no Supreme Court case out there saying this is a violation of privacy, because remember, good guys get caught in this as much as bad guys do. Some states have already got statutes that require warrants for the use of Stingrays. Texas does not. And the way it looks, it got brought up this past legislative session, and nobody cared. And on the appellate court level, this is why I think this issue is ripe for a Supreme Court hearing, because the appellate courts are split. You got the 7th Circuit that said you can use these Stingrays to massively collect this data around you at all time without a warrant. And then you got the DC Circuit, which I am utterly surprised at this one, that said use of a Stingray requires a warrant. So you guys remember about class, I talked about that a little bit, about the whole split of authority, and that's how you get stuff in the Supreme Court when I talk about Marbury versus Madison. This is it. This is the right issue, because Stingrays have been around since 2007. And they are commonly used right now on the federal level by the Department of Homeland Security, IRS's Criminal Investigation Division, the FBI, the DOD, I already said Homeland Security, ICE, and the Border Patrol. You go cross over into Mexico, I guarantee you your cell phone's going to run through one of those. So what this is, and I call it attempts to bypass Carpenter, that's what this is. They are trying to bypass Carpenter, the case that says you've got to get a warrant to get that cell phone information. The information here on these phones that is just automatically given to the carriers. They're trying to bypass it without going through the courts, without getting warrants. Stingray technology is one of them. But here's the one that is relevant as of 2021 with data brokers. As of 2 months ago, the U.S. House Committee on Oversight and Reform opened an investigation into a company called Ventel. Ventel openly says they collect data and collect and sell data from American mobile phones to government agencies for warrantless tracking. They are okay saying that is their business model and that is what they do. You know how they get your data? They're not getting it directly from the carriers, because I'll talk about the carriers in a second. Say you got a weather app. Say you pull open weather.com. There is a potentiality that weather.com, with helping you find the location where you're at, is sending your precise location down to 25 feet to the weather.com servers to help you find where your weather's at that day. Mobile games. Mobile games. If you ever notice mobile games, what do they always ask for? You've got an Android phone. The reason I'm using the Android phone right now goes for this purpose. They ask you for permission to the phone portion of your actual mobile phone, and they ask for your contact list. They are aggregating this stuff, guys. They are aggregating this stuff, and they're selling it to the government. It's happening every day. This is $1 billion industry that is happening around us. And so mobile games, just think of this. The next time you download something, think of that in the back of your head. I'm not trying to make everybody paranoid. I'm just trying to tell you the truth, okay? That there is some data broker out there that is harvesting all that information and then selling it. And all this started out harmlessly a number of years ago, where they would harvest this data and they would sell it to retarget ads to you, to give you more relevant ads that would show up, right? On those free games and all that free stuff, the free apps. That's how it started. But when Carpenter happened, the federal government started approaching these companies saying, hey, will you sell us that data? We don't have to get a warrant for it. And companies like Ventel saw $1 million, billion-dollar business in the making right there. And so that's what they do. They are unabashedly selling this information to the federal government and to the state government. So here's who's purchasing CLI right now from data brokers. The IRS Criminal Division, the FBI, the DEA, Homeland Security, DOD, ICE, and the U.S. Border Patrol. The same ones that are using Stingray technology. And the state and local agencies are also, in addition to this, purchasing information regarding social media use. When you use Facebook, or when you use any of the mobile social media, and they want your location data, just remember what they're doing. Yeah, they want to give you that nice little tag saying, oh, look at this cool picture I took wherever I was on vacation at. Just remember, that's sending your location down to 25 feet of social media companies. And here's the information they're gathering. The IMEI, that individual ID, the so-called social security number of the cell phone. They're sending your cell phone number, they're sending that geolocation data down to 25 feet, they're sending your contact list, they're sending your demographic information you willingly put on these apps. And also, we don't know this for certain, but there's no reason to believe they're not sending health data to you. Why would they be sending health data? It's a little thing called COVID-19. And that's opening up a brand new world we don't even know about that's going on with this type of sale. So, yeah, I'm not trying to be doom and gloom about anything, but, all I'm saying is there's a world of stuff out there that could cause problems. And be careful is the message I'm trying to say. There's potential solutions to this. The Electronic Communications Privacy Act could potentially do this, but it has not been amended since 1986. How good is that going to be? Right now it has no teeth at all to deal with social media, to deal with cell phone technology, to deal with any of that. It is dealing with old wire phone lines, landlines. It is not dealing with any of this stuff. And recently, a couple senators got together and they proposed something called the Fourth Amendment is Not for Sale Act. And I love the name.
I like that name.
I love the name. You want to take a guess which senator proposed this?
had to have been Rand.
Exactly.
And Paul.
That's who it was. He came up with the name. I love it. Yeah, Rand Paul came up with it. And the idea is they want to prohibit data brokers from and government agencies from being able to buy and sell to each other. They want a prohibition on that. But here's the problem. Let's say that passes. Let's say this passes this year. Is this going to stop quid pro quo? Is this going to stop them from a government agency going to a company that's selling this stuff, like the IRS, saying, yeah, I know you guys hadn't filed your taxes in about 4 or 5 years, and y'all made about $3 billion last year. Hey, how about we just make that little problem go away if you give us some of that data? That ain't going to go away. So for every solution we get, there's another loophole. That's really what I want to get to. So how did we get to this point? Well, the carriers, AT&T, T-Mobile, Sprint, before they merged with T-Mobile, and Verizon admitted to selling location data. Back in 2019, they admitted to it. They got sued. And they readily admitted to doing this. And then one of the best ones that came out of that was one that happened with Sprint, where they figured Sprint only served a low-income population. So you had this one company come out of nowhere and literally say, okay, we are going to sell location data to bail bondsmen and bounty hunters. So here's what happens. Sprint sells the data to some data broker, and this data broker is selling it for commercial purposes, for ads, but also he's selling it now to this other shady one that's selling it to bail bondsmen and bounty hunters. But why? Oh, because Sprint only deals with the impoverished people of the country. So you have profiling right there that's being done in the background. So what happened? The carrier said, we're sorry, we'll never do that again. We'll never do that again. Yeah. After they got sued for how many millions of dollars, I mean, they're great lawsuits on. But what happened? The carriers go away, but then companies like Ventel come up, the one I just talked about. They come out of the woodwork. When there's a way to make money, people will find a way to sell. It doesn't matter what it is. When there's a way to make money, people will find a way to sell. And that's, to me, the existential crisis we have right now with data privacy is data brokers. There's got to be a solution. There's got to be a solution this quick. Because that's the thing to call your congressman about. Is somebody needs to support. I love the name. The Fourth Amendment's Not for Sale Act. Is it going to solve every one of these problems? No. But is it at least going to put a stopgap on making a billion-dollar industry out of selling our information to the government? So I can be optimistic there.
I'll be honest, I want to see it just because I want to see that.
I want to see the name.
I want to see that little text that says, this shall be known as the Fourth Amendment is not for sale act written in the U.S. Code.
Exactly. I want to see that. So the last thing I want to talk about today, I'm taking off my lawyer hat. I'm putting on my historian hat because this is Constitution Day and I want to recognize a member of the Texas House of Representatives from right here in Snyder. Gentleman by the name of Reno B. Rawson. He was a captain in the U.S. Army Air Corps in World War II, and he served in the House of Representatives from the 56th through 63rd legislative session from 1959 to 1975. And the pictures I'm about to show you right now came from the Scurry County Museum right here on campus, Building 26, you can't miss them. And these are some great pictures for local history that I'm now getting involved with. So here's Mr. Rawson right here with Preston Smith, the governor of Texas back in the 60s. So these are some great photos. These are some great photos that are absolutely locally relevant. And so part of Constitution Day is bringing it home to and bringing it relevant here at home. And that's why I really wanted to show these pictures to show that this local community has contributed a lot over the years. Mr. Rawson was on the jurisprudence committee that helped amend the family code, to the family code, and this is your world years ago, but he helped amend the family code to the more modern family code, and he was a proponent of that. So one cool thing he did. Here's another picture of them right here with some other state representatives. I believe this was in the 62nd session based on the session data that we got of it. And last but not least, I want to show this picture here of LBJ, Lyndon B. Johnson, with a very well-known guy from Scurry County, Clarence Thurston McLaughlin, also known as C.T. McLaughlin. He was a philanthropist. He was involved with the Democratic Executive Committee of Texas during the 1950s. He was also a very well-known oil man and had a very big ranch about 12 miles outside of Scurry County, or I'm sorry, outside of Snyder. That's him right here on the right. With LBJ, if anybody knows LBJ, one of the infamous presidents, stay tuned for 1302, we'll talk about him a lot. And I just want to say one last thing before we end, is I want to say thank you to Tessa Holiday over here. She's the director of the Scurry County Museum. I'd like to thank Drew for being here too. He's on the board for WTC and also with the museum. And I really appreciate y'all's help with this. It helped out a lot, and I wanted to bring everything home. And on a more positive note than the doom and gloom I started spreading here for a while, Victor, obviously you helped do this.
Appreciate it. Yeah, thank y'all so much. This
Thank
is
you guys so much for
the
coming.
first event of the semester, and looking forward to the first of May.
Yeah. Look forward to Veterans Day because we'll be doing some stuff on Veterans Day too. So thank you guys so much for coming. Enjoy the rest of your day, and hopefully I didn't scare you too much. We didn't scare you too much.
Happy Constitution Day.
Yeah, absolutely. Happy Constitution Day.